Failing to understand the FDCPA isn't just a mistake. It's a significant financial and legal risk for your business. Think FDCPA is only for agencies? If you collect your own debt using a different business name, you could be just as liable. And the rules are expanding. Traditionally, for consumer debt, some states like California now apply similar protections to small business debts. The penalties aren't minor. We're talking fines per violation that can snowball into crippling financial losses. In the next few minutes, we'll break down the forbidden practices you must know, from communication limits to deceptive tactics. First, be clear. The federal FDCPA applies to personal, family, and household debts. If that's what you collect, these rules are non-negotiable. One of the most potent consumer rights is the written cease and desist. Once received, nearly all communication must stop or you're in violation. Your legal clock starts from the first contact. You have 5 days to send a written validation notice detailing the debt and the consumer's right to dispute it. A massive area of risk is misrepresentation. You cannot mislead about the amount, character, or legal status of the debt, even by mistake. How common is this? 56% of CFPB complaints are about attempts to collect debts not owed. This is a major tripwire for businesses. Deception also includes who you claim to be. You are strictly forbidden from implying you're an attorney or a government agent if you are not. Now, why are these rules so broad? It's because of a legal concept you must understand: the unsophisticated consumer standard. This means your actions are judged not by what a lawyer understands, but by how an inexperienced or trusting person would perceive them. This standard is the lens for your scripts, letters, and voicemails. What matters is the potential effect, not your intent. This standard explains the 5-day validation notice. It's a mandated mechanism to ensure every consumer understands their rights. Are your communications compliant? Another rule prohibits unfair practices like adding unauthorized fees. You cannot collect extra charges unless the original agreement allows it. This leads to a point on threats. You cannot threaten any action you cannot legally take, like arrest or wage garnishment, without a court order. Let's review specific communication violations. Rule 1, call frequency. You cannot call a consumer more than 7 times in 7 days for one debt. Rule 2, contacting people at work. If you know their employer forbids it, or if they've told you to stop, any call to their job is a violation. Rule 3, talking to third parties. You can't discuss the debt with anyone but the consumer, their attorney, or spouse, period. This third-party rule creates a huge problem for a common practice. So how can you even leave a voicemail without breaking the law? These rules are precise. Think about your team's current call scripts and frequency. Are they safe under these guidelines? The answer to the voicemail dilemma is the limited content message. A script that identifies you but never mentions the debt, avoiding disclosure. The challenges extend to modern technology. Social media is a minefield. You cannot publicly post about a debt. Private messages carry immense risk. The same risk applies to email. Sending a collection notice to an address you know is the consumer's work. Email is generally prohibited. Unfair practices also get nuanced. For instance, you cannot threaten to repossess property if you have no legal right or no actual intention of doing so. Even payment handling is regulated. Depositing a post-dated check before its date is a violation. So is asking for one just to threaten prosecution. We've covered communication rules and deceptive tactics. Now let's connect the dots. Why are these rules so specific? Recall the unsophisticated consumer standard. Threatening arrest works because a vulnerable person might believe it's possible, even if it is not. That same standard explains the 7 calls in 7 days rule. The law presumes that level of contact is harassing to an average person, regardless of your intent. Ultimately, FDCPA compliance isn't just a checklist. It's a perspective shift. You must evaluate every action through the eyes of a naive consumer. Let's review. First, you might be covered by FDCPA even if you aren't an agency. Second, your communication is strictly limited. Third, misrepresentation is a key risk, and the stakes are high. Violations accumulate, leading to massive fines, lawsuits, and damage to your ability to operate. Your immediate next step is to conduct a thorough audit of your collection practices. Review your scripts and training against these rules. In debt collection, what you don't know will hurt your business. Adhering to the FDCPA is not optional. It's necessary for survival.